Good afternoon, and welcome to the final round of the Myerowitz Moot Court competition. My name is Jeff Johnson, and I'm the Moot Court Board Vice President. We have a very exciting final round planned today with a distinguished panel of judges and some very talented competitors. I'm going to go over the program for today, but first I'd like to recognize the chairs of this competition, Doug Sampson, Susan Schipper, and Cody Mason. These three wrote a very interesting and challenging problem, read every brief, and judged every oral argument. Having done a fraction of that work myself, I can tell you this is no small task, and they deserve a hand. Now, as for our program today, you will first hear from Doug Sampson, last year's best oralist, and then our dean, Donald Tobin, who will give you some introductory remarks. We will then give a recitation of the facts and the record which our competitors will be arguing today, so that you have a better understanding of the oral argument. After this recitation, our Myerowitz chairs will introduce the judges and our competitors. As for argument, we will have two competitors arguing for the petitioner and two for the respondent. Each competitor will have a total of 15 minutes of oral argument, with the petitioner reserving time for rebuttal. After our oral argument, our judges will deliberate, during which time we will announce the new members of the Moot Court Board, and also the winners of Best Brief and Runner-Up Best Brief. Once our judges are finished deliberating, our judges will provide feedback to our competitors and will announce the winner of Best Oralist and Runner-Up Best Oralist. And Dean Tobin will then give closing remarks. After the competition is complete, we'll have a reception outside in the atrium, and everyone is welcome to join us there. So now, Doug Sampson.
Good afternoon, everyone, and thank you very much for coming. The four individuals in front of you have worked extremely hard over the past 2 months, and they all deserve to be commended on the amount of work that they've done. It's my privilege to introduce the Dean of the Law School, Donald Tobin, who is also one of the nation's leading experts in campaign finance, which happens to be one of the issues that you will be hearing argued today. Dean Tobin joined Maryland from the Ohio State Moritz College of Law, where he was a law professor, the Associate Dean of Academic Affairs, the Associate Dean for Faculty, and a senior fellow at Ohio State's election law program. Dean Tobin previously served as an appellate attorney in the tax division at the U.S. Department of Justice and as a clerk for the Honorable Francis Murnahan of the Fourth Circuit, and began his career on Capitol Hill as a professional staffer for U.S. Senator Paul Sarbanes. With his expertise in campaign finance law, Dean Tobin has published numerous articles on the use of the tax code to regulate campaign financing, and most recently co-authored the interactive textbook Federal Income Taxation, A Contemporary Approach, and we were also honored to have him serve on our panel in the semifinals, which several of these competitors argued in front of in this competition. Here's Dean Tobin.
I'm not used to the podium being backwards for me. Thank you. Thank you, Doug. I appreciate it. Good afternoon, everyone. Welcome to the final round of the 2015 Morris Brown Myerowitz Moot Court competition. The four finalists we'll hear from today had the highest combined score for brief and oral advocacy of everyone who competed. They were judged by a jury of their peers, plus distinguished judges and me, and some practitioners. As one of the people who was a judge, I can assure you that this is a very impressive group. This was an incredibly tough problem. One half of the problem is an area I know extremely well, and I'm not sure I could have argued the case for that side. It was very, very complicated. As you know, I spent a lot of years as an appellate attorney at the Department of Justice, and it was one of the greatest jobs that I ever had next to this one. I got to appear before most of the courts of appeals in the nation, and I didn't have the benefit of a program like this. I didn't do moot court. And my first argument was somewhat of an embarrassment. Nobody had kind of warned me about what would happen, and when the judge looked at me and said, "What's wrong with that person's argument?" and all I could think of in my head was, that was the stupidest argument I've ever heard. And had this little nervous grin on my face, and Judge Arnold, who was the chief judge then of the 8th Circuit, looked at me and said, "What's so funny, counselor?" I knew that I had not gotten off to a good start. So experiences like this are great opportunities for our students to be able to get the kinds of experiences that makes them professional before they start in practice. And so it's a really terrific program, and so glad you're all here today with us. I want to thank the Moritz Brown Myerowitz family. He's class of '68. He died 2 years after graduation. more than 30 years ago, and his family established this competition as a tribute to him. So we have this wonderful tradition here, and it's because of them, and so I want to thank the family. We also have some previous participants of the Myerowitz, and many of them are some of our most notable alumni. And so I saw Judge Dan Friedman in the back, class of '94, who is now on the Maryland Court of Special Appeals. And that was one of the first events that I got to go to when I came as dean, was his do they call it swearing in, or do they call it something else more fancy? Swearing in, good enough? So I got to do that. And Jonathan Church, who is the '02 grad and a deputy state's attorney in Anne Arundel County. And just in case I'm missing anybody, could anybody who competed in this as an alum raise your hand in the room, because I want to make sure I didn't. And could you just tell me who you're?
Mark P. Simone.
Oh, sorry. We have you in a second for a thank you for your work on the whole program. Sorry. And then I saw the Honorable Diane Leisure here, and thank you for all your work that you've done. She's retired from the 5th Judicial Circuit. She helps us with the class and is an advisor to our Moot Court Board. So thank you so much for everything you did. And our co-chairs of the Moot Court Board, Cody Mason, Doug Sampson, and Susan Schipper, and our board president, Michelle Dion. Thank you so much for all that you do. And now to Mark for the work you did on our national trial team, and also for your help in giving feedback for the problem. So thank you so much. So finally, I have the pleasure of introducing today our panel of distinguished jurists. And this was another really fun thing that I got to do, was to try to talk to some of the judges to see if they would be here today. And the first judge is the Honorable Pamela A. Harris, who's the judge of the U.S. Court of Appeals for the 4th Circuit. This is a special judgeship for me, because I clerked for the Francis Murnahan, who had this seat 2 times ago. And then, of course, our distinguished alumnus, Andre Davis, had that seat before now. So it was so special for me to be able to get her in her first year to come here and judge our competition. She was nominated by President Obama in 2014. She has a long and varied career with great public service. She's a graduate of Yale College and Yale Law. She clerked for Harry T. Edwards of the U.S. District Court of Appeals for the D.C. Circuit. She clerked for Justice John Paul Stevens of the U.S. Supreme Court. She was an attorney advisor for the Office of Legal Counsel at the U.S. Department of Justice, and she was in private practice for a decade. She also taught at Penn and at Georgetown. She was the Principal Deputy Assistant Attorney General, Office of Legal Policy at the Justice Department, and the Executive Director of the Supreme Court Institute. So you can see how she became a Court of Appeals judge. So she will be one of our 3 judges here today. The second is the Honorable George J. Hazel, Judge, U.S. District Court for the District of Maryland. He was also nominated by President Obama and also received his judicial commission last year. Judge Hazel's career combines private practice and public service. He's an alumnus of Morehouse College and Georgetown Law. He practiced at Weil, Gotshal, and Minaj in D.C. for 5 years. He was the Assistant U.S. Attorney in D.C. and then in Maryland, where he was the Southern Division Coordinator of Project Exile, a program to combat gun crime in our state. Judge Hazel was serving as Chief Deputy State's Attorney for Baltimore at the time of his judicial appointment. And our third judge today will be the Honorable Michelle D. Houghton, Judge, Maryland Court of Special Appeals for the 4th Appellate Judicial Circuit. I think most of you are familiar with Maryland system, but we have a district court, a circuit court, a court of special appeals, and then our highest court is our Court of Appeals. She was appointed by Governor Martin O'Malley in 2010, the first African-American woman to serve on the Maryland Appellate Court. She's an alumna of the University of South Florida's College and of Howard Law, began her legal career as an assistant state's attorney in Prince George's County, private practice in both a firm and sole practitioner, specializing in litigation. She began judicial career in 1994 with the appointment to the District Court of Prince George's County, and 18 months later was promoted to the Circuit Court, the first African woman to hold this position in Prince George's County. As you can see, we have a remarkable panel of jurists with us today, a remarkable group of students who are going to be competing with us today. Thanks to all of you for joining us, and I think I turn it over to, come on up. Thank you.
Hi everyone, My name is Cody Mason. I'm one of the Myerowitz co-chairs this year. I'm just going to briefly, or as briefly as I can, go over the facts for this year. So in 2011, Leslie Knope was elected governor of the state of Pawnee. Although originally focused on economic issues, Knope's allies passed a gun control law after the state suffered its first ever fatal school shooting in 2013. The gun law, among other things, prohibited the public carrying of firearms, except under certain circumstances. One exception was for a citizen to gain a public carry permit by demonstrating a legitimate reason to the state police commissioner, who would then decide whether to issue the permit or not. Ron Swanson, a millionaire and former ally of Governor Knope, unsuccessfully sought a permit after a man broke into his family's home. Swanson's application was denied because he failed to demonstrate a unique or compelling threat or harm. His appeal was also denied. Around the same time, Swanson created a nonprofit called Pawnee Leadership Action Partnership, or PLAP. PLAP then created two different political action committees with the acronyms of One PAC and Dose PAC. One PAC would coordinate with and give donations to political candidates. Dose PAC was organized to only engage in independent expenditure activities, uncoordinated with candidates or One PAC. Swanson's business partner, Jerry Gergich, became the executive director of PLAP, and two local celebrities joined the boards for both PACs. Both PACs were managed by the same lobbyists, and Dose PAC made some financial contributions to One PAC, despite having separate bank accounts. Both were funded to support gun rights and economic development in Pawnee. One PAC did this by donating to and coordinating with Jeremy Jam, a state senator challenging Governor Knope in the 2015 election. Dose PAC ran ads contrasting Knope's record with Jam's political positions. Years earlier, and after a corruption scandal in Pawnee, Pawnee had enacted a $5,000 contribution limit that would apply to both One PAC and Dose PAC. Ron Swanson sued Pawnee to invalidate the gun law and to stop the $5,000 cap from applying to Dose PAC because he wished to contribute more to defeat Leslie Knope. Swanson prevailed in the district court, but that decision was overturned by a divided circuit court panel. His cert petition was then granted by the Supreme Court, and that will be the case that our competitors today will be arguing. Thank you, and I'll turn it over to Susan Chipper to introduce our competitors today.
Thank you all. I'm so excited to introduce our really wonderful competitors today. First, we have Ashley Wetzel representing the petitioner for Issue 1. Ashley is a second-year student at the University of Maryland School of Law, and she came to law school after graduating from Colgate University. Ashley is a member of the Women's Bar Association, a peer advisor, a 2L SBA class representative, and a University Student Government Association senator. Last summer, Ashley worked for the Juvenile Division of the Frederick County State's Attorney's Office, and she currently works as a research law clerk for the law offices of David L. Rubin. Next up, we have Benjamin Garmo. Benjamin Garmo is representing the petitioner for Issue 2. Benjamin graduated from the University of Maryland, Baltimore County in 2013. He is currently a member of the Maryland Law National Trial Team, the co-president of the Maryland Carey Service Corps, and the president of Legally Sound, the law school's a cappella group. While at UMBC, Benjamin helped restart the mock trial program there, and he now serves as a coach for UMBC's undergraduate mock trial teams. Prior to law school, Benjamin worked for the Honorable Judge Sherry L. Krauser of the Circuit Court for Prince George's County, and last summer he clerked for the law office of John Van Hoven. Next up, we have the respondents. Jules Zanton, representing the respondent for Issue 1, moved to Maryland in 2009 to attend Johns Hopkins University. At Hopkins, Jules majored in political science and served in the Army ROTC. He graduated in 2013 with a BA in political science and commissioned as a second lieutenant in the U.S. Army. At Maryland Law, Jules is a teaching fellow in the Academic Achievement Program and serves as the vice president of the Jewish Law Students Association. While in law school, he has worked as a judicial intern for Judge Douglas Nazarian of the Maryland Court of Special Appeals, a legislative intern for Maryland Delegate Chris West, and a summer legal extern for the U.S. Army JAG Corps. He will be working at the Center for Health and Homeland Security this summer. Finally, we have Holly Leisure representing the respondent for Issue 2. Holly is a third-year evening student. She serves as a 3E class president for the Student Bar Association, and she is a peer advisor. Holly earned the title of Best Oralist in the 2014 Fall Moot Court competition. Holly is a 2008 magna cum laude graduate of Stevenson University, where she earned a bachelor's degree in paralegal studies. For 6 years, Holly has been employed as a full-time paralegal at the law offices of Peter G. Angelos. So welcome to our competitors, and we're very excited. The round is about to begin.
All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated, please. All right, counsel, you may proceed.
Good afternoon, Madam Chief Justice, Your Honors. May it please the Court, my name is Ashley Wetzel, and I represent the petitioner, Mr. Ronald Swanson. This is a case about the government's destruction of a responsible, law-abiding citizen's Second Amendment right to bear arms. This court should overturn the 12th Circuit Court of Appeals holding and find that Pawnee's Firearm Safety Protection Act is unconstitutional for 2 reasons. First, the right to bear arms outside of the home is protected within the historically recognized scope of the Second Amendment. And second, Pawnee's Firearm Safety Protection Act should be reviewed with strict scrutiny and found unconstitutional because it is not narrowly tailored to a compelling government interest. This court held in Heller that when determining the scope of the Second Amendment, courts should look to historical and textual evidence. Although this court has not definitively ruled on the matter, it is clear that the right to bear arms in public is historically and textually within the scope of the Second Amendment.
Counsel, excuse me, what evidence is there that you're aware of that indicates the Second Amendment extends outside of the home?
Your Honor, there's an abundance of evidence both before the ratification of the Second Amendment, at the time of the ratification of the Second Amendment, and after the ratification of the Second Amendment. This court in Heller they cited the Blackstone commentaries, and the court found that the Second Amendment stems from the natural right of resistance and self-preservation as a public allowance. And additionally, the court recognized an individual right protecting against both public and private violence before the enactment of the Second Amendment. So necessarily, this implies that the right to bear arms extends both inside the home to protect against private violence and outside the home to protect against public violence.
Counsel, I read the decision in, is it Peruta?
Yes.
Where the majority of the Ninth Circuit, right, agreed with you.
Yes.
And did that historical analysis, but then the dissenting judge did an equally weighty and long historical analysis, looked at the exact same materials, and came out the other way. And so I guess my question is maybe kind of a method question. I mean, I'm a judge. I'm not a historian. What am I supposed to do with this? There's this mountain of historical evidence. It obviously goes both ways. Judges can disagree. How am I supposed to answer that question?
Your Honor, it's true that the historical evidence does go both ways. And it's true that there may always be able to find a case that will go the other way. But the court in Tyler and also the court in Ezell said that the burden to prove that the regulation regulates conduct outside of the scope of the Second Amendment falls with the state. And if there's inconclusive evidence or history goes both ways, then the court should fall on the side of protecting individuals' rights. And I think that it's clear after the Second Amendment, in addition to history before the ratification of the Second Amendment, courts have continually struck down bans on carrying pistols openly in public. For example, in Nunn v. State, the court talked about the natural right to self-defense and struck down a ban on carrying handguns openly in public. Similarly, the court in Andrews v. State in 1871 struck down a ban on carrying pistols openly in public, even though people could legally carry long guns.
Counsel, just so I'm clear on the facts, this regulation pertains to both open and concealed carry, so are you suggesting that sort of half of it implicates the Second Amendment, but the other half doesn't?
I'm suggesting that half of it implicates it even more significantly, but I think that because this law encompasses both, it's important to look at laws in both. And there's also some precedents, for example, Bliss v. Commonwealth, which was decided in 1822, that struck down a concealed carry ban as being unconstitutional. So there is evidence that the law protects both the right to concealed carry and open carry in public.
Although, and then I'm sorry, I'm taking more than my fair share of the time, although Heller itself, right, talks about restrictions on concealed carry as having a long historical pedigree, and they're sort of presumptively permissible, right?
Yes, it's true. Heller itself talks about the concealed carry, but Heller also gives you the broad kind of framework to look at the historical and textual evidence not necessarily referenced in that individual case, but that does exist. So I think that opens the door to bring in cases like Bliss versus Commonwealth that strike down the ban on concealed carry and other cases that strike down bans on open carry.
Now, you seem to assume in your opening statement that this was a strict scrutiny analysis, but as I understand the law, I mean, there are still ways in which someone could carry a gun. You just have to make certain showings. So isn't this really just sort of a burden, and then such it should be intermediate scrutiny?
Your Honor, we are of the opinion that Pawnee's Firearm Safety Protection Act can't survive any level of scrutiny because it amounts to a complete destruction of the Second Amendment right. We are urging the court to review it with strict scrutiny, and we think that there's the strongest argument there.
How is it a complete destruction if there are still ways for them to exercise their Second Amendment right?
The Pawnee's government and the law claim that there are still ways for someone to carry a permit, but it is unclear what those ways are. It seems as though Mr. Swanson had a perfectly legitimate reason in order to need this permit. He had a home break-in, an intruder, a drunken intruder, entered into his daughter's bedroom, and he was able to keep the intruder at bay at gunpoint until the police arrived. But with this new law, he would be unable to do that, and if that's not a legitimate reason.
Can't he have a gun in his home? I thought this was about carrying a gun in public.
He can have a gun in his
So
home,
that
but
would have taken care of his problem, right?
it would take care of that specific problem.
But that's the only specific problem sort of we have in front of us, right?
But, Your Honor, it's unclear what an actual legitimate reason would be to have a gun in public, because he has the specific threat, and although it was in his home...
Oh, I'm sorry, is there an ongoing threat? The person who broke into his house continues to threaten him?
There's not a clear ongoing threat, but I think the fact that you can't always know when a threat is going to appear. You can't always know when something's going to happen.
In that respect, he's just situated like every person in the world, right? You just never know.
In this respect, he doesn't have an ongoing threat, but he does have that previous threat. And there's no evidence that this person was arrested or that this person will be unable to threaten him in the future. So I think that in and of itself is a legitimate reason that he should be able to carry. So, as I said, this law would not pass either level of scrutiny. When determining the appropriate level of scrutiny, courts should look to the closeness that the regulation comes to restricting the core of the right. This court in Heller stated that the core of the right is for a responsible, law-abiding citizen to practice self-defense, and in Heller the court did say that the right is at its apex in the home, but there's no language in either Heller or McDonald that forecloses upon the possibility that the core of the right extends beyond the home.
Well, wouldn't you infer from the statement you just made that it does not extend beyond the home?
Your Honor, respectfully, I would not say that it does not extend beyond the home. The Heller court did not definitively say one way or the other whether or not it did not extend beyond the home. And if they could have said that it distinctly did not extend beyond the home.
Certainly, if it's at its apex in the home, that suggests that it's at something less than its apex outside the home. Is that not a fair statement?
It may suggest that it's something less than its apex outside of the home, but it does suggest that it in fact can exist outside of the home, because apex does not imply that that's the entirety of the core, just the heightened procedure of the core. And in addition, other courts, lower circuit courts, have found that the core of the right actually does extend beyond the home. The court in Moore found that to combine the core of the Second Amendment right to the home would be to divorce the Second Amendment from the holdings of McDonald and Heller. Similarly, the court in Puerta, as Madam Chief Justice was citing, states that the core of the Second Amendment right to self-defense takes place wherever a person happens to be. It logically does not make sense that one has the right to defend themselves on their front porch, but the second that they step onto their sidewalk, they are no longer entitled to that core right of self-defense.
Although lots of constitutional, well, I mean, there are other areas of constitutional law that do recognize something special about the home, right? You have more Fourth Amendment rights in your home, you have more privacy rights in your home than you do the second you walk outside your home. So it's not, I mean, it's not a line that is unfamiliar to the law, right?
That's true. Other amendments do recognize that this right is outside the home, but even in places or in cases where they've talked about the justifiable need or legitimate interest kind of permitting scheme that apply outside the home, our law is distinguishable from those cases, even under an intermediate scrutiny standard, so our law would still not pass constitutional muster. For example, the Fourth Circuit in Willard v. Gallagher reviewed a good and substantial reason law and found this was a challenge by someone whose permit was denied, but in this case there was a very clear standard as to why this person did not have a good and substantial reason. Specifically, people who had good and substantial reasons were those engaged in certain business activities, regulated professionals such as security guard, armored car drivers, etc., assumed risk professions such as judges, police, public defenders, etc., and then personal protection. Unlike this law, our law stopped at personal protection. Our law said that it cannot be a vague threat. This law instead gives factors to take into account when determining whether a person actually needs that personal protection.
So just to back up for a second, I assume then you are conceding that the state did at least have a legitimate interest in passing this law?
Yes, Your Honor. It's clear that the state does have a legitimate interest in maintaining public safety.
And so in terms of trying to find a way to put forward public safety, what better way is there than to limit the number of guns that are walking around on the street?
Your Honor, this provision is not narrowly tailored or closely related to that public safety. For example, as I was saying, they need to tailor this to say specifically what a legitimate reason constitutes so people can know how to get those guns if they
So
are.
if they were to define legitimate interest, would you then agree that it's a constitutional statute?
Your Honor, I think it would definitely be closer to being a constitutional statute if they were to properly define legitimate interest. But again, there's a significant amount of police discretion here, so it's unclear that it would be uniformly applied to all people.
Don't all laws involve some discretion in the hands of the people who we put in charge of enforcing those laws?
It's true, Your Honor, that all laws inform some kind of discretion, but this is a law that's restricting a fundamental right to all citizens unless they have an exception. They should definitely make sure that the law is applicable to all citizens, especially responsible law-abiding citizens. In this case, responsible law-abiding citizens are denied the fundamental right just because they don't have a special exception. So that's not...
No, they're denied the right unless they have a legitimate reason.
Right, and that's not narrowly tailored, though, because there's no clear standard as to what the legitimate reason is.
But, counsel, again, as I understand the record, at least your client, he sought this exception, and his explanation for why he needed it was that the only way he'd be able to reduce the pain and trauma that he had already experienced was by carrying a gun. Like, under what? I mean, maybe the standards could be a little more precise, but that's got nothing to do with safety, with any kind of new threat. It's just that he feels a lot of pain and trauma, and as a result, he'd like to carry a gun. That seems like not the most compelling case in the world for why you should be allowed to carry a gun, that you're experiencing a lot of trauma.
Your Honor, pain and trauma that come with almost every threat. So even in cases where someone had a direct
Did he
threat.
rely on an ongoing threat from the person who broke into his home before the board or whoever it was who was supposed to whom he applied for this application? Because they said he didn't, that there was no ongoing threat that he had identified. And so I guess I'm asking, do we need to make a whole big constitutional mess out of this? It sounds like what you really think is that the person in charge of approving the application got the facts wrong. Like, in fact, there is an ongoing threat. They said he didn't say anything about an ongoing threat. They've just kind of passed each other at a factual level.
No, Your Honor, there's no clear ongoing threat, but I think the fact that individual law-abiding citizens like Mr. Swanson, who, Your Honor, I see my time is up. May I answer your question? Like Mr. Swanson, who are in this position, who, in addition to being an individual, typical law-abiding citizen who would like to exercise his fundamental right to carry a gun, he has an additional factor that weighs into his need for the gun. So I think that this court should find that the may carry issue is unconstitutional.
Thank you, counsel. Counsel, please.
May it please the Court, good afternoon. My name is Benjamin Garmo, and I'm here today on behalf of the petitioner, Ronald Swanson. Honorable Justices, this case is about the freedom of speech at its fullest and most urgent potential, and about Pawnee's unconstitutional efforts to level the playing field. This
The
Court
ability
should
to give
overturn-
money is the most fundamental aspect of speech.
I'm sorry, Your Honor, I didn't hear that.
Repeat your first statement regarding how important money is to the aspect of speech.
At this point, Your Honor, this Court has held that when money is related to political campaigns, that is where it is at its fullest and most urgent application. As it relates to political campaigns and as it relates to individuals using their speech and how Buckley has related money to speech, dollars to speech, that it is at its apex when we're working with political campaigns, that our ability to express our freedom of speech for a political campaign is what is fundamental to the First Amendment. And so this law is unconstitutional for two reasons. First of all, DOSPAC is an independent political expenditure committee. And as a result of that, this law on its face, as it regulates independent expenditure political action committees, is unconstitutional.
How can you assert that the PACs are separate when there's such a network or intermingling of staff and resources and funding?
Respectfully, Your Honor, it's our position that what's dispositive here is not the intermingling or the commonality of the staff, but in fact two specific factors. The first one was laid out in this court in the Colorado case from 1996, and that's the actual coordination with candidates. That if you're dealing with the Citizens United concerns of either corruption or the concerns of appearance of corruption, that we don't have direct corruption in this case. We don't have what Colorado defined as direct coordination with candidates, and we don't have the appearance of quid pro quo corruption. And the reason is, and the jurisprudence guides us in a number of cases, for example, the 10th Circuit in King, or the D.C. Circuit in Emily's List, or the D.C. District Court in Carey, that the identity of having both organizational separation and separate bank accounts in this instance demonstrates that these are in fact separate entities.
Now, you mentioned, I'm sorry.
No, please.
You mentioned separate bank accounts. Isn't it the case, as I understand it, that one PAC was actually giving money to the other PAC?
Yes,
So,
Your Honor.
As a
Last
practical matter, I mean, you can have separate bank accounts, but if you're ultimately commingling funds, what difference does it make?
Well, respectfully, Your Honor, we would disagree with the assertion that there's commingling of funds here. If you look at the record, last summer, the DOS PAC provided money to one PAC for certain projects at certain points. We don't have an affirmative assertion in the record that that is continuing. We know that it occurred in the past. There was no distribution of funds from one PAC.
Does it make a difference that it was one time as opposed to 15 times or 30 times?
Respectfully, Your Honor, yes, it does, because it goes to what the Vermont Court and the Second Circuit talked about in a fluidity of funds. That what we're looking at here is the appearance of corruption, the appearance of quid pro quo corruption. And the idea, in fact, it's rooted in a policy analysis, this idea that we don't want hard money controlling soft money. It's defined a few different ways. The district court, in this case, defined it as dominion or control. United States Code defines it as significant impact on decision making. So we're looking at the idea of the appearance of corruption. And when you look at the actual act of organizational separation, of filing to be separate entities, along with separate bank accounts that maintain their own funds and that don't transfer back and forth from one another, that goes towards showing that there isn't dominion or control.
I guess I don't understand why they would have to go back and forth, because if what you're worried about is sort of quid pro quo corruption, and maybe I'm just misunderstanding kind of the practicalities here, but I would think what you're worried about is the candidate will say to the donor, if you give me money, I will do X. Don't give it right to me. That's kind of embarrassing. Give it to my PAC. Or in this case, give it to the independent expenditure PAC, because that's fine, because they'll just write a check to my PAC. So why isn't it all the same thing?
Well, it goes, Your Honor, respectfully towards the appearance of corruption. That if you look at the logic behind the 10th Circuit and the D.C. Circuit and the D.C. District Court, their logic was that when you separate the bank accounts, if we set aside for a brief second, and I know that's difficult, but if we set aside for a second the idea of these transfers that occur.
I totally agree that if you set aside the transfers, that's the only thing I'm worried about is the transfers. And like Judge Hazel, I guess I don't understand why you could have 3 bank accounts, you could have 10 bank accounts. Who cares if the money is going from bank account 1 to bank account 2?
Well, Justice Hazel's point is a good one, Your Honor, and it's true that the idea that these funds were transferred in the past, it muddies the water a bit. There's no doubt about that.
Okay.
But it's our contention today that it doesn't rise to the level of the appearance of quid pro quo corruption that this court has recognized is what's necessary in order to rule that these groups are independent. That if you look at what's going on here, we're not dealing with a shadowy C4 organization that has no disclosure requirements here. We're dealing with an independent political action committee. And the organizational aspect of this, the fact that they're organized separately, I think that can be easily overlooked, but it's important in this analysis. That the fact that this is not a hybrid political action committee. These are two separate arms that, while they do maintain certain staffing commonalities, the Fourth Circuit in North Carolina Right to Life recognized that wasn't enough. That just because there is some commonality between staff, that doesn't rise to the level of either of the two prongs of actual corruption or the appearance of quid pro quo corruption.
It's more than just some commonality of staff, though. Don't you have pretty key people working in both?
There are two common board members, Your Honor, that there are two board members that serve on both boards. And then other than that, there are separate staff. While they work on the same floor, they work out of separate offices, and the staff do separate things. While they sometimes work together, and that's understandable because these are political action committees that they're not hiding, they're working towards the same goals. They were formed for the same purposes, but they work separate from one another to achieve those goals. And it's understandable, for example, what happened with Councilman Jam and his campaign. That Councilman Jam began associating with one PAC, and thus Dose PAC began to support Councilor Jam. If you look at the the Second Circuit's analysis in Walsh, this idea that there are certain instances in which political speech is at its most potent. And one of those is right after a candidate has declared. If you look in this instance, the Dose PAC, whose stated objective is to support candidates who have positions similar to, say, what Councilman Jam had, Councilman Jam declared, and soon after that, Dose PAC began to support his positions as understandably they would. That doesn't rise to a level of the appearance of quid pro quo corruption. It's what Dose PAC was designed to do.
Can I ask you a question about sort of the structure of your argument? If you assume for a minute, really just for the sake of argument, that I was to think that maybe these two groups are sufficiently intertwined, what with the transfer of money, that we're going to treat them as one entity that does make direct contributions. Is that the end of the case for you, or would you still argue that the First Amendment would prohibit these restrictions?
Respectfully, Madam Chief Justice, it's not the end of the case. It's not the end of the case for two reasons. If this court were to recognize that this was a direct political action committee, there are two methods in which this court could still find that this law is unconstitutional. First, under intermediate scrutiny, this law is not sufficiently related to a governmental objective, and in fact, this law seeks to unconstitutionally level the playing field, which has been prohibited by this court in a number of instances. The idea that this interest in regulating the speech of those who may be more affluent is not an acceptable method of doing so. But respectfully, Your Honors, this court should recognize that all direct campaign contributions should be guided by strict scrutiny. It's an analysis that I anticipate that the respondent will argue, in fact, that if you look back at the Buckley analysis, that this idea that quid pro quo corruption is a governmental interest that must be governed through intermediate scrutiny when you're dealing with direct contributions. While Buckley at its time was certainly important, Buckley is coming up on its 40th anniversary. And the idea that direct contributions need to be regulated this heavily simply was imagined with this current scheme of today of C4 organizations and hundreds of millions of dollars in campaign contributions. That simply didn't exist in the past. And if you look at the current interests nowadays, the way that this law applies to direct contributions restricts Mr. Swanson's and anyone else's abilities to express the freedom of speech. And in fact, it guides the distribution of donations away from the open disclosure that we desire in a system of government like ours, that we have this.
So we would have to overrule that part of Buckley to come out that way?
To come out that way, yes, Your Honor. We would have to recognize that
So that's what you're asking, right?
Yes.
And what would be the justification here for sort of disregarding stare decisis? You may already have alluded to it, but tell me why.
Certainly. It's rooted, Your Honor, in a policy notion that if you look at what's happening now, that because direct contributions are regulated so heavily, they are essentially funneled away from PACs or direct PACs which have heavy disclosure requirements and into 501c4 organizations or bundling organizations which don't have those same levels. In the 2012 presidential election, the top 3 C4 organizations gave over $100 million. Those are astronomical amounts that weren't even within the realm of possibility when Buckley was first envisioned. The system has changed. The system has
Change circumstances.
I'm sorry?
Change circumstances, that's sort of what you would root this
Absolutely, Your Honor. The system has changed. Now, there have been courts that have recognized this. The Ninth Circuit, for example, in Long Beach, recognized that certain contribution limits on direct contribution could be limited or banned altogether, or could not be, because there wasn't that governmental interest in regulating them. Now, I recognize that this court has, in fact, seen that there is a lessen limit or lessen restriction in quid pro quo corruption in indirect contributions. But when we're dealing with
Counsel,
direct...
you focused on corruption. Aren't there other interests that we should consider in examining this law, other than corruption?
Respectfully, no, Your Honor. This court has held in Citizens United, in McCutcheon, even as far back as Buckley, that when it comes to restricting independent expenditures or even direct expenditures, the only thing that this court, and that courts in general, can consider is this danger of quid pro quo corruption. And it's that justification that was led to justifying these limits on direct quid pro quo corruption. And it's for that reason that it's our position that, in fact, those ideas of this direct quid pro quo corruption are outdated. In fact, this court recognized that very fact in Citizens United. While this court didn't go so far as to strike down limits on direct contributions, it recognized that they are inherently preventative and that by their very nature, that the appearance of influence doesn't cause people to lose faith in their democracy. And that's the core issue of direct contributions, that they, in some views, may appear by some to be a corrupting influence. But this court recognized that that premise is flawed in today's system.
But you wouldn't need us to go, right, so far as to say that direct contributions from citizen to candidate can't be regulated. You only need us to say that direct contributions from a citizen to a PAC that makes direct contributions can't be restricted, right? We don't have to take the second step for you to win.
That's correct, Your Honor. And in this instance, if this court were to, say, hold intermediate scrutiny in this possibility, this law is still unconstitutional, and most notably because it seeks to level the playing field. That Mr. Swanson's speech should not be limited in this instance. That Mr. Swanson is limited to $5,000 in this particular instance. Mr. Swanson is a wealthy individual, and this court has held in a number of different instances that an interest in regulating these types of contributions is not to ensure that individuals who may have, or corporations who may have more resources, cannot give as much as they desire. That's not an interest that is recognizable in this case. But that's what this law does. Whether or not it was intended to do that, the limit of $5,000 serves to prevent people like Mr. Swanson from expressing their speech, from using their fundamental First Amendment right for the freedom of speech. So while it's our position that DOSPAC is in fact an independent expenditure political action committee, and thus for that reason this law should be struck down, this law should also be struck down if this court, may I briefly conclude, Your Honor, also be struck down because if this court were to rule that DOSPAC is in fact a dependent political organization. So for the following reasons, we ask that the 12th Circuit be overturned. Thank you.
Right, respondent. Counsel?
Madam Chief Justice, and may it please the court, my name is Jules Zanton. On behalf of the respondent, Governor Leslie Knope, in her official capacity as Governor of Pawnee. In District of Columbia versus Heller, this court held that the Second Amendment protects the right to possess firearms in the home. The court held that the Second Amendment has not protected the right to carry a concealed firearm in public, as the Chief Justice noted earlier, and does not prohibit states from enforcing other, quote, presumptively lawful regulations.
How can there be a true right to bear arms if you can't carry it in public?
Well, Justice, I would argue that there is some Second Amendment right that may extend beyond the home. This court has been unclear, circuits have been unclear, but this does not prohibit citizens from carrying firearms in public. It has no limits, for instance, on long guns, shotguns, and rifles, as you can see on pages 8 and 9 of the record, and does allow citizens to carry handguns, a class of firearms which is easily concealed.
But to the extent that self-defense is ultimately the issue here, what's the difference between self-defense in one's home and self-defense in public? Doesn't one actually need more typically self-defense outside of one's home than in public?
Your Honor, the Second Amendment, the extent of the Second Amendment is not determined by a sort of interest balance inquiry. The extent of the Second Amendment is determined by precedent, history, and tradition. Precedent, history, and tradition simply do not suggest that there is any right to carry handguns outside of the home, and does not suggest that the Second Amendment is as robust outside of the home as it is inside of the home. As the Chief Justice said earlier, many of our constitutional rights, our Fourth Amendment rights to privacy, our protection against unreasonable searches and seizures, even in some cases our First Amendment rights, are more robust within the home than outside of the home. Even if Pawnee's handgun statute does implicate the Second Amendment, which we do not believe to be the case, it would properly be analyzed and upheld under intermediate scrutiny, as it does not implicate the core Second Amendment right and is reasonably related to Pawnee's important government interest in public safety. Your Honors,
Well, if you're effectively taking away someone's right to carry a gun outside of their home, how is that not implicating the core of the Second Amendment right? You're taking away their right to bear arms just when they're outside their home.
well, Your Honor, I would respond in a couple ways. First of all, we're not taking away their right to bear arms because they can still possess a long gun. They can still possess a rifle or a shotgun outside of the home. Indeed, in the enactment of the Firearm Safety and Protection Act, an assault weapons ban was considered but ultimately rejected. And the permit requirement does not extend to anything other than handguns.
But in reality, I don't think you expect many people to be walking around the street with a shotgun around their arm. So, I mean, we're really talking about handguns in terms of how people would choose to exercise their right to self-defense, aren't we?
Respectfully, Your Honor, if I felt that my life were in danger, and
You'd walk around with a shotgun?
if in a case of an emergency, in a case of public disorder, in a case where there was rioting or looting, if I felt that that was the way I could protect myself, I might do that. I would not choose to walk to the law school carrying a long gun.
I think that'd be appreciated.
I'm glad. The Third Circuit held that New Jersey's statute, which has very similar handgun restrictions to the restrictions that Pawnee enacted, does not implicate the Second Amendment because the restrictions on both the concealed carrying and open carrying of handguns are the sort of long-standing regulations that enjoy presumptive constitutionality under the teachings articulated in Heller and expanded in court precedent. Accordingly, the Third Circuit held that the New Jersey statute, very similar to the Pawnee statute, regulates conduct falling outside the scope of the Second Amendment.
Counsel, can I ask you the same question I asked your counterpart and ask you to respond to her answer? If the historical evidence seems like it's either an equipoise or I'm not enough of a historian to figure out whether or not it's an equipoise, your counterpart says, well, you can use a burden-shifting regime to figure out the answer, and the burden should be on the state to show, or the city, to show that something falls outside the Second Amendment. Do you agree with that this is your burden to show that this particular use of a gun is not covered by the Second Amendment, or is it the petitioner's burden to show that it is?
I do not agree with my colleague on that point. I think that courts should be reluctant to find statutes enacted by legislatures unconstitutional. I don't think that the presumption is that any gun law in America after Heller and McDonald is unconstitutional. And I think that, as the Third Circuit showed in Drake versus Filco, there is a presumption of constitutionality for these gun laws, because Heller said that many gun laws, Heller enumerated certain types of gun laws which were very clearly not implicated by the Second Amendment, but then they said that this list of presumptively lawful regulations is not exhaustive. So I think that there is a presumption of constitutionality that a gun law enacted by the states should hold, especially considering how many states have prohibitions on some type of open or concealed carrying, or have regulatory schemes for open carry and/or concealed carry.
As I read Heller, it does talk specifically about the long historical pedigree of concealed carry restrictions, but it doesn't really say the same thing about open carry. I mean, is it your sense that those two things rise or fall together, or is it possible that you might treat them differently?
Well, Your Honor, in her argument, my colleague conceded that appeared to concede, I believe conceded that if this law were only about concealed weapons, it would not be a constitutional challenge. And I think she's right. I think the court has spoken very clearly on that. In Robertson versus Baldwin, this court held over a century ago that the Second Amendment is not implicated by laws prohibiting concealed carry. So really what we're talking about is open carry, and not just open carry, but open carry specifically of handguns. Now, handguns are a class of firearm that even if they're not concealed, they're easily concealable. And that's why they're the weapon of choice for criminals. They're very easy to store in a glove compartment, to store in a jacket. And therefore, we would suggest that they should receive a similar treatment under the law as weapons that are actually concealed. A concealable weapon and a concealed weapon are similar, especially considering that handguns are so often used as concealed weapons by citizens who do not obey the law.
Now, you mentioned intermediate scrutiny in your earlier argument. Are you conceding that you would lose under strict scrutiny?
Your Honor, we don't concede that we would lose under strict scrutiny. We don't believe that that is the proper way of analyzing it. But let's say that we were to. The test for strict scrutiny is whether a law is narrowly tailored to a compelling government interest. Now, my colleague recognized that there is an important, and I believe she would concede that there's also a compelling government interest in public safety, a compelling interest in Pawnee making sure that the sort of school shootings that occurred at Donald Meagle High School never, ever happen again.
And how is this law narrowly tailored to address that issue?
This law is narrowly tailored because it specifically targets a class of firearms that are used by criminals and are either carried in a concealed or concealable way. This law does not implicate long guns, and this law also does not implicate individuals who can show, who can convince the Commissioner of Public Safety and a court through an appellate process, if necessary, that they face a special ongoing threat, the sort of threat that my colleague recognized that her client no longer faces now that the home break-in is in the past. Your Honor, the test for intermediate scrutiny versus strict scrutiny, because you mentioned strict scrutiny, and I stated that I did not believe that was the proper analysis. The proper test was articulated by the Seventh Circuit in Ezell versus the City of Chicago. The test for analyzing whether a law which regulates the possession of guns should be analyzed under strict scrutiny or intermediate scrutiny, quote, depends on how close the law comes to the core of the Second Amendment right and the severity of the law's burden on that right. The Pawnee statute simply does not come close to the core of the Second Amendment. The core of the Second Amendment is the right to possess firearms in the home. In Heller and in McDonald, this court held that a statute which prohibited individuals from possessing firearms in the home is unconstitutional. And the history of Heller shows that there was a very specific decision to limit that case to the home. Indeed, when Mr. Heller challenged the District of Columbia's firearms statute, there were also very tough laws in the District of Columbia regulating the public carrying of firearms, and Mr. Heller chose not to challenge those. Those decisions were very clearly...
Well, it doesn't limit our ability to rule otherwise now, does it?
Well, it doesn't, Your Honor, but this court was very clear in both Heller and in McDonald not to say anything about the extent of the Second Amendment right outside of the home. And
well, doesn't the fact that we didn't decide it then just leave it for another day, such as today, to decide that maybe it does extend that far?
Your Honor, it does leave it for another day, but this court has traditionally relied on the circuit courts to develop case law before it comes back to the Supreme Court. And what the circuit...
So are you suggesting that we should just kick the can down the road again and not decide on whether or not this involves the public?
No, Your Honor. I would suggest that this court should adopt the viewpoint of most circuits to consider the case, of most federal circuits to consider this issue, and hold that the core Second Amendment protection is limited to the home. That's what the Second Circuit held in Pachalski.
We can't really do that, though, because then it's like an endless feedback loop, because those circuits rely on the fact that we didn't say it in Heller. So the whole thing, I mean, I think we're going to have to make up our own minds here. You see what I'm saying? The circuits who have said that it's not, that public carry isn't at the core of the Second Amendment have relied on Heller to say that. So we're not getting a full independent.
Your Honor, I would agree with you that the circuits were relying solely on the court if that were the case.
Well,
I
not
don't.
solely, but they use Heller in their analysis, right?
Heller does inform them.
Right.
But other things inform them as well. One of the things that it informs them is the general constitutional principle that Your Honor articulated yourself during my colleague's argument, that constitutional rights are generally strongest at the home. There are generally fewer competing interests within the home. My right to do as I please in my home poses less of a challenge to the public, less of a challenge to other people.
I'm still not sure I understand why someone who is under attack in their home has a greater right to defend themselves and more of a need to rely on the Second Amendment protections than somebody who's standing on the street and is attacked by someone.
Well, Your Honor, anyone has a right to protect himself. Pawnee common law has a defense of self-defense, as does every state. And anyone can protect themselves. Anyone can protect themselves with a long gun, no matter what. And anyone who does face an ongoing threat, the sort of threat that Mr. Swanson does not face, can acquire a concealed or open carry permit in Pawnee. The reason why the right is strongest within the home is because the right within the home poses less of a threat to other people. There's less collateral damage from the license to harm that is the right to possess a firearm in the home. Fewer other people could be hurt. When Pawnee enacted this law,
Counsel, of the Second Amendment. What's really at the core of it? Is it the locale or is it something else, a little deeper?
Your Honor, I would suggest that it is the locale, and that is informed by history. Our history as Americans of wanting to have firearms primarily to protect ourselves in the home. As this court noted in McDonald, when Congress passed the Civil Rights Act following the Civil War, and ultimately passed the 14th Amendment, which incorporated the Bill of Rights, they were concerned that southern states, after Reconstruction, were violating the right to self-defense of African Americans by taking away their firearms. And the court noted that, quote, bands of armed men would enter black families' homes, confiscate their weapons, and proceed to commit outrages of every kind and description, said the court, quoting the Congressional Globe. Now, the threat existed most profoundly for these individuals in their own home, and they needed the right to possess firearms in their own home most strongly, because that's where their children slept at night. That's where they were being attacked.
So it's not the home, it's not the location, it's the self-defense that is really the core.
Yes, Your Honor, I might agree that the need for self-defense is strongest in the home. That's where we sleep every night. That's where we should expect to be on a lower level of guard than we are in public when we walk down the street and rely on the police to protect the public square. Your Honors, because the core of the Second Amendment, because the Second Amendment is strongest in the home, this law should not be analyzed under strict scrutiny. It should be analyzed under intermediate scrutiny, and I think it's very clear that when analyzed under intermediate scrutiny, it does. This law is reasonably related to the important government interest of protecting the sort of violent crime and school shootings that Pawnee tragically experienced in the Don Amigo High School and experiences every month and every year in needless, senseless, preventable gun violence. Your Honor, for the reasons articulated, the state of Pawnee respectfully requests this court to uphold the 12th Circuit's grant of summary judgment to Governor Knope and the state of Pawnee. Thank you very much.
Counsel?
Good afternoon, Madam Chief Justice, and may it please the court. My name is Holly Leisure, and I represent the respondent, Ms. Leslie Knope, in her capacity as governor of the state of Pawnee. Governor Knope respectfully requests that this court affirm the decision of the United States Court of Appeals for the 12th Circuit as it relates to Pawnee's Campaign Fairness Act applied to DOSPAC for two reasons. One, DOSPAC is not an independent expenditure committee, or political action committee. And two, Pawnee's Campaign Fairness Act, as applied, would survive intermediate scrutiny, which is the proper standard of review that this court should use.
Regarding your first point, explain to me why it's not independent. My understanding is they do have a separate organizational structure. They have separate bank accounts. They have very limited staff overlap. Why is it not independent?
Your Honor, those points are true. However, I can give you a list of reasons that DOSPAC and OnePAC are significantly intertwined. As we know, they were both created by PLAP and have the same executive director. Both of these organizations are managed by twin lobbyists, by two twin lobbyists. All of the staff are paid by PLAP, and the OnePAC staffers who are bringing their knowledge and the information that they know in working on OnePAC projects, they're coming to DOSPAC and working on their projects, often, as the record states. Additionally, they do share office space, and most of their major meetings are joint. You can imagine that in these major meetings, there's a good chance that information that OnePAC would have learned from corresponding with Senator Jam could be learned by members of DOSPAC. And perhaps, and with all of these factors, one or two of these we may agree may not sufficiently intertwine both of these political action committees, but when you combine all of these and then perhaps the most obvious factor, which was discussed during the petitioner argument, is that the funds have been transferred to OnePAC. So
That was one time, correct?
Your Honor, the record is not clear whether it was one time. We know that it was during the summer, but Your Honor, even if it was only one time, that is something that is strictly prohibited for an independent expenditure committee. This independent expenditure committee, this is what they signed up. This is what they are legally considered. So they're violating what is considered and what's actually in Pawnee's Campaign Fairness Act. So separate bank accounts, as one of the justices, I believe, pointed out earlier in petitioner's argument, that it's somewhat pointless if you're going to go ahead and transfer these funds. And we know that DOSPAC's independence is key to this issue, because independence of an independent expenditure committee is the linchpin that holds together the principle that no limits can be placed on contributions for independent expenditures. And we know that from Stop This Insanity.
And do you agree with that principle? Are you conceding that principle, that if in fact it's an independent expenditure PAC, then no limits can be placed on contributions?
Your Honor, while the respondent recognizes that it would be a difficult road and it would require this court to overturn previous cases, it is possible that even as I believe you're implying, that if this court were to apply strict scrutiny, that DOSPAC could not be applied to DOSPAC. It would be a difficult road, but I think there's still a possibility.
But you're not urging it here. You're not asking us to do that, or are you?
If the respondent does not think that it's necessary for the court to go this far in this case, because this case is really dependent upon whether DOSPAC is independent from OnePAC.
Right. But assuming arguendo, only for purposes of argument, that we were to think it was independent, would you then what?
Yes, Your Honor. So in that instance, then this court would need to apply strict scrutiny. And if we apply strict scrutiny in this case, and understood that we do understand that many of the cases do say that intermediate should be applied for direct contributions, and that strict scrutiny should be applied in this case, it would be difficult, but I think we could still win in this particular instance, because we know that it has to be a narrowly tailored law, and we know that there must be a compelling government interest. I'll start with the compelling government interest. We're not just dealing with we are dealing with preventing actual or quid pro quo corruption, as we know from Buckley, as we know from Citizens United. But this isn't just a preventative act. This isn't just something that Pawnee's government has heard about in the news. This is something that Pawnee has firsthand experience. We know that in 2011, there was a director, a very wealthy director, very similar to Mr. Swanson in this case, that actually was able to give $10 million to the governor, and as a result, the governor was giving contracts that should have been evenly divided throughout other contractors in Pawnee, that he was giving these to the Sweetums Candy Corp.
So that goes back to corruption, and I think most people would concede that corruption is an interest. Is there any interest beyond that?
I think the courts have said that corruption is the main interest. Now, this court could potentially go further and say that because we're dealing with we're dealing with the appearance, that the appearance of corruption could go further, looking into influence, looking into bribes that maybe aren't obvious to the naked eye.
You've suggested a couple times that we could do things. I guess the question is, should we? Are you arguing that we should do that?
I would argue that this court should consider that we are dealing with different times. We're dealing with this court could still do this and still uphold the principles of Buckley. And in most of the cases that have been decided in this court, the main issue, again, as you mentioned, has been corruption, but it's also been the fact that they're looking at whether there's been prearrangement and coordination between the Political Action Committee and the candidate themselves.
Counsel, I'm sorry, I just want to make sure I'm understanding where we are in the argument. When you say these are different times, right, different from Citizens United, because that wasn't that long ago, and in Citizens United, right, we held that there is no anti-corruption interest in regulating contributions related to independent expenditures, right?
Your Honor, that is true,
Okay,
but
so what's changed since then that would make us reconsider that?
So maybe it's changed since then, and perhaps maybe it was even happening before then, but what I think we're seeing more often is either these hybrid organizations like we see in Emily's list, and there's several others. There's one in Texas, a Catholic organization. So we're beginning to see more hybrids, and we're beginning to see that these, similar to this situation where you have a nonprofit committee that has been, a nonprofit organization that's been created, and then you have these two arms extending. There's a great possibility for these PACs to circumvent the system, essentially. Even if we take, for instance, and we argue that only once, that transfer only occurred once, we don't know how much money was transferred from DOSPAC to one PAC, and so if we allow independent expenditure committees to act or to really be under a guise being called an independent expenditure committee, but then small allowances are made for those, for donations to be made to contribution committees, or there to be some sort of commingling, then we come into a problem where there really is a potential for quid pro quo corruption.
But counsel, on that point regarding the insurance of independence of the PACs, what guidelines should we create to ensure that independence, so that it's clear?
Your Honor, I would ask this court to look at the Vermont Right to Life case that was decided. In those instances, there were the overlap of staff and resources, a lack of independence, financial independence, which we're dealing with here, the transfers. If we're looking at coordinating activities, and also just the flow of information. So I would ask that we would be asking that this court not allow meetings between independent expenditure committees and direct contributions, and these sort of, really the hybrid organization itself, it would be difficult to have a hybrid organization. So perhaps this court should allow what we think, or what PLAP has given us the image of, which is that there's a direct contribution committee and that there's an independent expenditure committee, but require that of course, as we know, they should have separate bank accounts, but also that everything remains separate, so that they're two totally separate sources. They're not commingling their money, they're not commingling their staff, and they're not commingling their knowledge.
So any one of those would be enough to say they're intertwined for these purposes. You're not asking us, all we'd have to say in this case is that when you have them all present, that's enough to say it's intertwined. But you would like us to go further and say any one of these things, the intermingling of staff, the intermingling of funds, or what was the other one, the intermingling of knowledge?
Yes.
Even if only one of those things is present, that's enough to call them intertwined. If you share one staff member, same person sort of answers the phones for both.
I think in that instance, this court could go that far. That might.
Well, what are you asking us to do?
What, Your Honor, what we're asking you to do first is to find that DOSPAC and OnePAC are intermingled, that DOSPAC is not an independent expenditure
And why?
committee.
What's the next sentence? Because
We think that intermediate scrutiny should be applied in this instance when viewing Pawnee's Campaign Fairness
no, I'm
Act.
sorry, they are intermingled because what? How do we finish that sentence?
sorry,
What makes them intermingled?
I'm sorry, Your Honor. Yes, so they are intermingled because they are financially enmeshed, as we know from Vermont.
Okay.
I think the financial enmeshment is the most important factor. However, I do think that it certainly makes a more compelling case when we have the other factors present. What I might also add in this instance is that on top of all of these things, we know that there was an ad that was produced by OnePAC, but during the summer, produced by DOSPAC, produced by the entity in question. And we know from that ad that not only was both candidates were presented, Governor Knope's views were presented, and we know that Senator Jam's views were presented. However, at the very end, it says Pawnee deserves better. Now, while yes, it doesn't say vote for Senator Jam, one can certainly imply that that's what that means, and we're dealing with express advocacy. So the fact that DOSPAC presented this, we know that OnePAC works on particularly large projects. I would think that an ad would probably be a particularly large project. So this is another example of a reason that you should find that they are significantly enmeshed. And again, intermediate scrutiny should be applied when we're looking at Pawnee's Campaign Fairness Act. As we've discussed, there's a sufficient important state interest, just as there would be if you are applying strict scrutiny, preventing actual or quid pro quo corruption, which we know has occurred in Pawnee. And additionally, I would also say that with regards to the law and to the amounts that have been brought up, using the $5,000, Beaumont and Ognebene tell us that we should be really deferring to the legislature to solve the problems that are created. And so in this instance, the law is not only narrowly tailored, but it would also be closely drawn if we use the intermediate scrutiny analysis. I would also point out that during the petitioner's argument, most of the argument was spent dealing with finding of a direct contribution committee and how the law should be applied to a direct contribution committee, which should lead this court to consider the idea that they really are enmeshed and that petitioner, while maybe not conceding, is at least acknowledging that there's a strong point.
Counsel, can I just ask you, there are a bunch of cases, right, from the lower courts finding no enmeshment, no impermissible intertwining when we have things like shared staff, shared meeting space, shared meetings. So long as there are these two separate organizational structures, two separate charters, that's enough. Are you asking us, it could be either one, do you think those cases are distinguishable or do you just think they're wrong?
Your Honor, two brief points. One is that I think there is such a circuit split that this court does need to make a final, certainly needs to make a final determination, which is why we see that. And I think that this case is different in that you weren't dealing with an enmeshment of financial funds. And again, I do think that the financial funds is the most important part to distinguishing these entities. Your Honors, in conclusion, DOSPAC is enmeshed financially and otherwise with OnePAC, a committee that is that's contributing directly to Senator Jam. I see my time has expired. Thank you.
Thank you. Do we have rebuttal? Oh, Counsel, I'm sorry.
Again, Your Honors. I would disagree with opposing counsel's statement that the core of the Second Amendment right is the right to bear arms in the home. This is not what this court said in Heller. According to Heller, the core of the Second Amendment right is the right to self-defense. Although Heller acknowledges heightened importance in the home, the core is not in the locale of the right, but the core is in self-defense. I would urge this court to determine that the core of the right actually does extend beyond the home. There is no clear reason why the core would not extend beyond the home, and Heller and McDonald contain no provisions foreclosing upon that possibility. Additionally, this point is supported by the lower court opinions in Moore and Puerta. As opposing counsel stated, this is not a balancing test. To quote Puerta, for if self-defense outside the home is part of the core of the right to bear arms, and the California regulatory scheme prohibits the exercise of that right, no amount of interest balancing under a heightened means and scrutiny can justify the policy. And in this case, there is no amount of interest balancing that can justify this policy. In conclusion, because the right to bear arms in public is within the scope of the Second Amendment and does not pass any level of scrutiny, we respectfully ask this court to overturn the 12th Circuit's ruling and find that Pawnee's Firearm Safety Protection Act should be found unconstitutional. Thank you.
May it please the court, I'd like to briefly respond to 2 points that the respondent made. First of all, regarding the idea of the separation, the dependency or independency. Respondent, relied on 2 specific cases from different circuits, Stop This Insanity and Catholic Leadership. It's important to note in each of those cases that those were cases that were dealing with hybrid political action committees. And in those cases, they asked that basically in a hybrid setting that those PACs needed more. That's exactly what we have here, members of this panel. This isn't a hybrid case. But there have been other circuits, for example, the Emily's List case in the D.C. Circuit, that have recognized even in a hybrid situation, the separation of bank accounts was dispositive in that case in indicating that they were, in fact, independent. And
Were they transferring funds in that case?
I'm not aware of whether or not there were funds that were being transferred in that case, Your Honor, but it's...
Wasn't that a pretty significant point? I mean, again, we come back to this issue of separate bank accounts, but if you're using the same money, what difference does it make that you actually have a separate bank account?
Well, respectfully, Your Honor, it's our position that what's dispositive here are the 2 major factors, that they are organized independently and that there were separate bank accounts in this instance that did not have the fluidity of fund.
Aren't you just asking us to ignore the reality of what's going on here? You have the same staff, you have similar funds, similar management, similar projects. It sounds like one PAC and those PAC are really the same entity.
Respectfully, Your Honor, we are not. We're asking you to recognize that these are 2 similar organizations, recognized under the same umbrella organization for the same purpose, but they do different things. And they are not, in fact, financially enmeshed. They are not intertwined. And we do not, as respondent implied, concede, in fact, that there is any validity to the argument that they, just by these facts alone, are intertwined. In fact, the reality that we see here is that, as respondent claimed, Mr. Swanson is not like the individual in the past who was responsible for corruption in Pawnee. Mr. Swanson is a law-abiding citizen who wants to use his right for freedom of speech to advocate on behalf of Second Amendment values to protect his family. Mr. Swanson wants to express freedom of speech.
Well, I don't think anyone is calling into question Mr. Swanson's motives, right? We're worried about the government officials who take his money, right? That's what we're worried about. No knock on Mr. Swanson. It's the other one. It's the other end of the transaction where we're concerned the corruption will take place, right? Because he gave me so much money, I will now do X. Isn't that the concern?
May I briefly respond, Your Honor?
Yeah, please. That's what I asked.
That is the concern, Your Honor. And that's precisely why we want this court to recognize that either under intermediate scrutiny or direct scrutiny, that these limits on direct contributions should be struck down, because that will throw these contributions into the open. It will allow the public to avoid the schemes that we're seeing now, these regulatory schemes of unlimited contributions to shadowy groups, and in fact will allow the public to see these contributions and react in turn to those contributions being made. So it's for the foregoing reasons that we respectfully ask this court to overturn the judgment of the 12th Circuit Court of Appeals. Thank you very much.
Thank you, counsel. So I guess court is adjourned.
All rise.
No, that's good.
they come back, we'll announce the winners of this year's Myerowitz competition.
Okay, and now for the announcement of the 2015-2016 Moot Court Board. When your name is called, please come accept your certificate and form a line behind. Molly Brimmer. Omar Bastami. Michael Cianfici. Colin Clardy. Benjamin Garmo. Diana Griffin. Hannah He. Michael Jacko. Sophia Jafrul. Daniel Caprow. Caitlin Leary. Holly Leisure. Laura Murky. Arya Robinowitz. Jeffrey Shaw. James Sheehan. Jules Zanton. Matthew Talmo. And Ashley Wetzel. And now we're going to announce Best Brief and Runner-Up Best Brief. Runner-Up Best Brief goes to Caitlin Leary. And Best Brief goes to Sophia Jafrul. Congratulations to the 2015-2016 Moot Court Board.
So just like in a real court, the judges have to have a little conference and decide what they're doing. So we're going to wait for their for their scores to come in. So we'll just be a couple minutes.
The judges are going to come back in. Thank you. The judges have made their decisions. So if everyone could take their seats. Perfect.
All right, so I just want to start by saying, and this is on behalf of all of us, how happy we were to be here today. It was a real pleasure to be here, an honor to be invited, and what a terrific job we thought you all did. I thought that was a tricky problem. Each of you had something hard to argue, and I just thought you guys handled it really well, and we are in agreement on that. And we would like to talk to you after we break, just to give you some more individualized feedback, but our bottom line is a job well done, and you guys should be really proud of yourselves. We do have 2 winners to announce. Our second place, and again, this was hard. I should just cut to the chase, but I do want to say this was really hard. It was there wasn't that much space between you. You were all that good. Nevertheless, we did the hard job of picking 2 winners, and our choice for second place goes to Ashley Wetzel. And for first place, Benjamin Garmo. That's all we've got, but we would really like an opportunity to talk to the 4 of you, if we could, just so we can give you some more kind of meaty feedback on a job very well done.
Thank you. So as a dean, it just doesn't get any better than this. Thank you, the judges, so much. I really felt like I was in a courtroom. I am a specialist on the campaign finance question, and I kept thinking to myself, how the heck did I answer that question? So it was really fun to be able to see it, and I know the time and preparation that you had to put in to make this work and to make it such a great experience for our students. So I want to thank again the Honorable Pamela Harris, the Honorable George Hazel, and the Honorable Michelle Hahn for all of it. Thank you. On behalf of the whole Maryland Cary Law community, I want to congratulate Benjamin Garmo for Ashley Wetzel, Holly Leisure, and Jules Santon for their just incredible work today. As I mentioned, I did this for a living. I've seen hundreds of these. I've mooted hundreds of these. This was really fantastic. You all did just such a phenomenal job. So congratulations to you. Thank you all for joining us today. Please join us for a reception down the hall in the Kronberg room, beginning now. So thank you all very, very much.
Congratulations.